by handing over an RDP house to Ms. Ntsaku during the Letsema campaign, resulting in the conflation between the state and political party lines. On the 23rd of April 2022, Mr. Ramaphosa attended the launch of the ANC Letsema campaign, and in the morning of the event, here, in the presence of Ms. Ntombela, handed over the keys of the Hillside View house to Ms. Ntsaku, which was paid for by the Free State provincial government. The investigation established that Mr. Ramaphosa was invited by Ms. Ntombela only on the launch of the Letsema campaign that morning to hand over the keys of a house to Ms. Ntsaku. He was neither aware that the handing over of a house would take place during the Letsema campaign, nor did he have knowledge that the house was paid for by the Free State provincial government, as he was informed that he would be handing over a house paid for by a private donor. Therefore, the allegations against Mr. Ramaphosa are unsubstantiated. However, the allegations against Ms. Sephora Ntombela, the former Premier of the Free State provincial government, is substantiated, in that she had the full knowledge of the processes that were undertaken that resulted in Ms. Ntsaku being handed over the RDP house. Accordingly, the conduct of Mr. Ramaphosa does not constitute improper conduct as envisaged in Section 182, 1 of the Constitution, and maladministration as envisaged in Section 64A1 of the Public Protector Act. The Public Protector has taken cognizance that Ms. Ntombela is no longer the Premier of the Free State and is not in the employ of the state, and therefore in this instance no remedial action will be taken against the irregularity. However, this report serves as a touchstone for all those who are charged with public power and authority. We therefore request that the Premier of the Free State, within 90 calendar days from the date of this report, in terms of Section 125(1) of the Constitution, to table it before the provincial legislature for deliberation in order to sensitize members of the executive of their obligations in terms of Section 136 of the Constitution. The MEC of Cocktail and Human Settlements, within 90 calendar days from the date of this report in terms of Section 7.3 of the Housing Act 1997, ensure that the HOD for Human Settlements undertakes the necessary processes to rectify the incorrect allocation of the Hillside View house to Ms. Ntsaku. The HOD for Human Settlements, within 120 calendar days from the date of this report in terms of Section 7.3, read with Section 7.5 of the Housing Act 1997, rectify the incorrect allocation of the Hillside View house to Ms. Ntsaku to reflect the details of the rightful owners in line with Section 16 of the Deed Registries Act 1937 as undertaken in the meeting held with the investigation team on the 5th of February 2025. Moving to report number 32, a complaint relating to irregular appointments of officials in the Bushbuck Ridge Local Municipality, namely Mr. P. Zwane and Ms. T.F. Mkwedi, who were allegedly appointed in the post of Occupational Health and Safety Administration Clerk, as well as Human Resource Administration Clerk, respectively. It is alleged that Mr. Zwane did not meet the requirements of the advertised post, which required candidates to have a diploma in human resource management and a minimum of 2 years working experience in the same environment. Mr. Zwane has a bachelor's degree in public administration without working in the occupational health environment. Similarly, Ms. Kwedi's appointment was questioned by the complainant, who alleged that she too was appointed while she did not meet the requirements for the position of Human Resources Administration Clerk. The advertisement for the position required the candidates to possess a grade 12 certificate without an option of an equivalent qualification, a national diploma in human resource management, and a minimum of 2 years' experience in the human resources environment. She too did not meet the requirements. The complainant alleged that the recruitment and appointment processes of the candidates were not done in line with the municipal policies, and the municipality had secured and reserved the posts for the appointed candidates. Our investigation and findings did confirm that both Mr. Zwane and Ms. Kwedi were irregularly appointed, as they did not meet the requisite academic qualifications and work experience. We also found that the conduct of the interviewing panel violated the Constitution and the municipality's employment practice policy. In terms of the remedial action, the executive mayor is therefore required, within 30 calendar days from the date of release of this report, to table the report before the municipal council for deliberation and obtain approval for the appropriate course of action to address these irregular appointments. The executive mayor, within 60 calendar days from the date of receipt of this report, to develop a system of delegation that would maximize administrative and operational efficiency and provide for adequate checks and balances. This should include strengthening of internal controls regarding recruitment in general within the municipality. The municipal manager is required within 90 calendar days from receipt of this report to initiate disciplinary proceedings against members of the shortlisting and interviewing panels, namely Mr. S.R. Shilenge, Mr. A.M. Mnisi, Mr. D. Hobiane, Mr. R.R.L. Muhlala, and Mr. S.P. Mukhanya, whose conduct resulted in the irregular appointment of Mr. Zwane and Ms. Kwedi. The municipal manager must, within 60 calendar days from the date of receipt of this report, ensure that all officials in the human resources management, as well as any employee who participate in the recruitment process, are properly trained to comply with the employment practice policy in order for future appointments to be made in full compliance with the policy. Further, in Report 34, which was the complaint regarding the allegation of improper conduct and maladministration in the Limpopo Department of Health by a departmental official, namely Mr. Mutibe Rhodes Msiza, who performed remunerative work outside his official duties without permission from the employer. The complainant alleged that maladministration occurred at the department, with a full-time employee of the department, Mr. Msiza, working at the Grobelstyle Hospital while simultaneously serving as a full-time ward councillor at the municipality. The public protector was requested to investigate whether the law allows a person to hold two positions simultaneously in government institutions, and if Mr. Msiza had made the required disclosures of his employment to both the health department and the municipality. Our investigation revealed that Mr. Msiza was elected as a ward councillor of Ward 31, Elias Mutsualedi municipality, from August 2016, and performed other remunerative work while employed by the Department of Health without obtaining the permission from the Executive Authority as required by Section 30, subsection 1 of the Public Service Act. He failed to comply with the provisions of Section 30, subsection 1 of the Public Service Act, in that his application to perform other remunerative work was only made 19 months after he occupied the position as a ward councillor. and such application was incomplete and defective and was further never approved. He, however, declared his financial interest to the municipality as required. Mr. Msiza continued to serve as the ward councillor with the full knowledge that he did not have the required permission from his employer until he resigned 4 years later. The Labour Relations Unit of the department failed to take corrective action against Mr. Msiza after the then Chief Executive Officer of Groblersdal Hospital, Dr. L.J. Rashukeng, referred the transgression to the unit for advice and action in August 2018. The department only took action on 12 January 2022 by instituting disciplinary proceedings against Mr. Msiza, who in turn resigned on the 25th of January 2022. However, these actions took place after the public protector had raised the allegations with the department. This was more than 5 years after the department had become aware of the matter. Mr. Msiza's conduct was in contravention of Section 7(3)(b) of the Public Service Act. The department also failed to execute cost recovery measures with regards to the remuneration of Mr. Msiza by the municipality while he remained in the employ of the department. The department also did not take any steps to recover the costs when he resigned. This is in contravention of Section 31(1)(a) Roman figure 2 of the Public Service Act that empowers the accounting officer to recover remuneration irregularly paid. Failure by the department to act promptly in dealing with the conduct of Mr. Msiza amounts to maladministration and improper conduct. Accordingly, the following remedial action is taken. The head of department is required to, within 30 calendar days from the date of receipt of this report, to institute legal proceedings against Mr. Msiza for the cost recovery of the remuneration irregularly paid to him by the municipality without the permission of the executive authority. The head of department must alternatively make a determination in terms of Section 31(1)(a) Roman figure 4 of the Public Service Act to approve the retention by Mr. Msiza of the whole or a portion of the remuneration he received in contravention of Section 30, subsection 1 of the Public Service Act. In the exercise of this discretion, as provided for in the above legal provision, the head of department must consider the seriousness of Mr. Msiza's conduct in this regard, who continued to serve as a councillor, knowing that he did not have approval of the executive authority to do so. The head of department must, within 90 calendar days from the date of receipt of this report, conduct a full audit in respect of all employees within the department who may be serving either as municipal councillors or in any other remunerative work, to ascertain whether they have obtained the required permission as required by Section 30, subsection 1 of the Public Service Act. In the case of transgression, implement necessary remedial action in accordance with the Public Service Act. The head of department must, within 60 calendar days, take corrective action against the following officials of the department for their failure and or delay in initiating disciplinary proceedings against Mr. Msiza in line with the provisions of the Public Service Act. There is Mr. N.Z. Mulefe, the Sekhukhune District Labour Relations Officer, as well as Mr. M. Mulebo, the Deputy Director, Labour Relations, Provincial Office. I move on to report number 36, whereby a complainant reported allegations of irregular appointment of Ms. M.C. Sipega as a Director, Community Services in the Maludi Apufong local municipality without meeting the minimum requirements for the position. The complainant alleged that in February 2020, the municipality advertised numerous vacant positions for senior managers directly accountable to the municipal manager, including the position of Director, Community Services. The positions were filled in July 2022, whereby Ms. Sipeka was appointed to the position of Director Community Services without meeting the minimum requirements. One of the requirements, as per the advertisement, was to have potential candidates undergo a competency-based assessment as required by law and regulations within local government. Through our investigations, it was established that Ms. Sipeka did not meet the requirements as she obtained a score of basic in the competency-based assessment and was therefore deemed unsuitable for a director position. It was also established that the selection panel did not reconvene as per the requirement to finalize its report recommending the appointment of Ms. Sipeka to the council for the said position. When the executive mayor, Mr. Gilbert Mukotso, presented the report to council, it was based on a draft report which was not signed off by the municipal manager, Mr. Futuli Mutama. This meant that the council was misled regarding the appointment. As a result, the council resolved to appoint the candidate. This means that the conduct of Mr. Mukotso and the council constitutes improper conduct. Accordingly, the public protector takes the following remedial action. The member of the Executive Council for Kokta must take cognizance of the report and ensure the implementation of the remedial action. The Speaker of Council is required to, within 60 calendar days from the date of this report, to take appropriate action against Mr. Mukotso, the Executive Mayor, for breaching the Code of Conduct for councillors. The Executive Mayor is required within 90 calendar days from the date of this report to table the report before the Municipal Council for deliberations and obtain approval to pursue a judicial review as provided for in Section 158, subsection 1H of the Labour Relations Act 1995 to address the irregular appointment of Ms. Sipeka as the Director, Community Services. The municipal manager must, within 60 calendar days from the date of this report, ensure that future appointments are made in full compliance with Section 56 of the Municipal Systems Act 2000 as amended and the appointment regulations. I move over to reports that have been finalized as a result of investigations resulting from the Executive Ethics Code. The detailed reports can be accessed on our website as well. Just to give some highlights on these investigations. Report number 33, an investigation into allegations of abuse of power and or improper conduct and breach of the Executive Ethics Code by the President of the Republic of South Africa, Mr. Cyril Ramaphosa. The investigation emanates from a complaint lodged by the leader of the Democratic Alliance, Mr. John Steenhuisen, on the 16th of April 2024. In his letter, the complaint stated that and requested an investigation in terms of Section 4, subsection 1A of EMEA into the conduct of the President stemming from the announcement he made on the 14th of April 2024 when he attended an African National Congress campaign event in Zandspruit, Gauteng, ahead of the elections. The President communicated the information during the ANC event or public gathering at Zandspruit on the 13th of April 2024, and at that time, the information was already out in the public domain. There is no evidence before the public protector to conclude that the statement by the President communicating what was previously communicated and announced by the Gauteng provincial government and already in the public domain was in violation of the provision of Section 96 of the Constitution. Moving on to report number 35, investigation into allegations that Mr. Bekokwakhe Hamilton Tele, the former Minister of Police, acted in breach of clause 2.1A to D, 2.3C, 2.3D, and 2.3F of the Executive Ethics Code by using public funds to attend the 2023 Rugby World Cup in Paris, accompanied by his executive assistant and exposed himself to a potential conflict of interest by accepting sponsorship from a private company. The allegation that Mr. Cele acted in a manner that is inconsistent with his office when he used public funds to attend the 2023 Rugby World Cup in Paris is unsubstantiated. Moving over to report number 37, investigation into allegations of maladministration and abuse of power by the President of the Republic of South Africa, Mr. MC Ramaphosa, regarding his conduct when he allegedly handed over a reconstruction and development program house to Ms. Martha Lowe in Donkerbroek, Northern Cape, during the African National Congress Litsima campaign held on the 1st of October 2022 is unsubstantiated. 39, investigation is unsubstantiated. Report number 40, investigation into allegations of improper conduct, maladministration, and/or abuse or unjustifiable exercise of power by the former Minister of Home Affairs, Mr. P.A. Motsoaledi, and the Premier of the Eastern Cape Province, Mr. L.O. Mabuyane, in relation to the designation of Bulembu Airport, Bisho, and the acceptance of a 20 million rand donation from the United Arab Emirates government, respectively, including the alleged failure by the South African Revenue Services to ensure that all goods and foreign currency were declared during the landing of the UAE delegation at Bulembu Airport. The evidence at the Public Protector's disposal shows that the proof of email sent by Mr. Makode to Ms. T.A. Forsi, the Chief Executive Officer, Government Printing Works, purporting to be the transmission of notice of designation, show that it was not responding. The evidence from Ms. Forsi also indicates that she did not receive an email from Mr. Makode on or about the 12th of April 2023. Resultantly, the publication of the notice of the designation only occurred subsequent to a follow-up email from Mr. Makode to Ms. Forsi on the 3rd of May 2023. The Public Protector noted with concern that publications of the designation of Bulembu Airport only happened on the 5th of May 2023, despite having been approved by the Minister on the 12th of April 2023. Although Regulation 8 of the Immigration Regulations does not prescribe timelines regarding the publication of the notice, it is reasonable to expect that it should precede the actual activity, which did not happen in this instance. In fact, by the time the designation was published in the Gazette on the 5th of May 2023, the UAE delegation had even left the Republic. The Public Protector also noted that although the Minister designated Bulembu Airport as a port of entry and exit in terms of Section 9A of the Immigration Act, read with Regulation 8, there is a need to harmonize these regulations with Section 30 of the Border Management Act. There must be clarity on the circumstances which would ordinarily trigger the application of Section 9A of the Immigration Act vis-a-vis Section 30 of the Border Management Act. This is so because whilst the Department of Home Affairs asserts that Section 9A of the Immigration Act applies in temporary designation to irrefutably show that it caters for such kind of designations. Considering the above observations, the following recommendations are made in terms of Section 4, subsections C, Roman figure 2 of the Public Protector Act, that the Minister of Home Affairs, within a period of 24 months upon receipt of the final report, takes steps to initiate and finalize the harmonization of Section 9 of the Immigration Act and Section 30 of the Border Management Act in the regulations to be promulgated in terms of Section 36(1)(k) of the Border Management Act. That the member of the Executive Council for Finance in the Eastern Cape Provincial Treasury within 120 calendar days, take steps to ensure that the Eastern Cape Treasury issues instructions in terms of Section 18, subsection 2A of the PFMA to regulate the acceptance of donations, gifts, and sponsorships by departments, whether in cash or in kind. As indicated earlier, these reports can be obtained on the Public Protector website, which is www.pprotect.org. Let me also emphasize that the remedial actions by the Public Protector are binding. Consequently, we urge all role players to implement prescribed remedial actions within the set timeframes. A lot of progress has been done in this aspect. Within 2 years, we have increased from 2% implementation of remedial action. To date, we are sitting at 39% of implementation of the Public Protector's remedial actions. Besides the issuing of these reports today, the Public Protector is establishing a satellite office here where we are at today at KwaMhlanga, which is aimed at expanding the Public Protector's footprint and bring its services closer to persons and in the greater KwaNdebele area and the surrounding areas. The move is part of the broader expansion strategy of the Public Protector to ensure that communities, especially remote communities, have access to services. Currently, the Public Protector South Africa only has one provincial office, which is situated in Nelspruit in Mpumalanga, which is over 300 kilometers from this area of KwaMhlanga. The satellite office will provide services to surrounding communities such as Siabuswa, Mulodo, Ukukhanyeni, Muteti, Pieterskraal, and others. Its proximity to these communities will save them time and money when they want to lodge complaints with the Public Protector. Other than Mbombela, some complainants used to travel to Pretoria, which is about 80 kilometers away, to access the services of the Public Protector. All these factors had contributed to the low number of complaints that the Public Protector had been receiving from the Mpumalanga provincial office over the years. When comparatively, when we had an office in Siabuswa, the Public Protector was used to receive between 70 and 100 complaints a month only from the Siabuswa office. Let me also amplify that the release of this fourth quarter report today then coincides with this launch of the satellite at the KwaMhlanga Magistrates Court. The opening of this office is going to attest to the broader outreach strategy which we are implementing. We also plan to open similar offices in other areas in the districts, and this is one of many offices that we plan to open countrywide. Some have been opened in other provinces. In an effort to ensure that members of the public are not left behind where we cannot reach them, we are also launching a self-service portal today. This will enable members of the public to lodge their complaints and also access progress of their complaints using their smartphones and any other electronic device through the internet. This portal also has a voice recognition feature to enable visually impaired persons to access our services. The self-service portal link is https://cma.pprotect.org. We have to bridge the digital and social divide, and in doing so, we are also launching our callback facility. This facility will enable members of the public to send a message for free to our call center agents to prompt them to call back. The callback number is 083-274-4124. As I conclude, I wish to express my dismay at the level of moral decay in our society, as the nation continues to struggle to comprehend with the case of a 7-year-old Twekwe in the Eastern Cape. The reality dawns that many similar cases go unreported. I am, however, encouraged to see that state institutions are taking the necessary steps to ensure that this matter is accordingly investigated. We condemn any act of violence against women and children. As we know, this act happens just 9 months since the Public Protector issued an investigation report on systemic deficiencies in our country's criminal justice system in responding to gender-based violence challenges. This then calls upon state functionaries to speedily implement the remaining remedial actions in this regard to ensure that the system is able to receive and process these matters accordingly, thus delivering justice to victims. In the same vein, the Public Protector is committed to contribute in the fight against the abuse of women and children through our investigation into the systemic deficiencies plaguing the child maintenance system in our country, which is progressing well, and we aim to finalize the investigation in the coming months. I thank you.
Thank you so much, Pipi. So we're going to start with a Q&A for any clarity-seeking questions on the issues that have been raised. So your colleague Mdntv will also be sending out the speech that the PP was focusing on for you to depend on in terms of direct quotations and things like that. So, but yeah, let's give you the opportunity to get any clarity on any particular issues. You know that generally you will introduce yourself and the organization that you represent, and then you can fire away. So let's see by way of indication of hands as to who we, anyone who would like to take a first step in terms of, all right, Ian, I'm sorry, Mr. Mapuda.
Yes. Thank you so much. Thank you so much, and good morning to the panel and people. Just a clarity-seeking question. My name is Cyril Ramaphosa from Newsroom Africa. I may have missed it, just I'm seeking clarity with regards to Ms. Ntombe, seeing as she is not in office anymore. Do you have any? I know that you found that her allegations against her are substantial, although no immediate action will be taken as far as she is not in office anymore. Is there anything which maybe you recommend with regards to that, what's going on with children? Thank you.
Thank you so much. Any other questions? In the absence of which one maybe say processing, I'll give to the PP and then she will outline as to who will be taking those particular questions.
There are no other
No other questions.
Oh, okay. We're so clear. I'll hand over to the COO to handle the response.
Thank you very much, PP, and good morning. In terms of the Constitution, indeed we investigate, we report, and we take remedial action that the Public Protector will deem appropriate under the circumstances. In this case, since Ms. Ntombe is no longer in government, there is no remedial action that has been taken by the Public Protector against Ms. Ntombe. However, as indicated in the report, we have taken remedial action to ensure that the house that was allocated to Ms. Ntsabo in this regard is then reallocated to the appropriate beneficiaries of that state-funded or subsidized house. So there is no further action that has been taken in terms of the remedial action against Ms. Ntombela, since she is no longer in the employ of government, because that is what our constitution requires and our mandate pertains to as the public protector. Thank you.
Thank you, Cyril. Just for the record, that was Advocate Medicine Kadinde. She's our Chief Operations Officer. Any other follow-up questions or clarity? I think I'm going to go once. We're good here, okay. I'll go once, twice. I think we will proceed here then if there are no other questions. As I was saying, we shall be sharing the media statement with you. We are always obviously available to assist with any other issues after this event so that we can give you any clarity that you may be looking for. That brings us to the end of the briefing. Thank you so much.
Thank you. Thank you so much.
Just last
Okay.